Ready? Okay. All right, good afternoon, everybody. My name is Judge Kim Teresa Malika. Today we're here to determine if there is probable cause and the bond that's going to be set and any conditions of release. You have a right to an attorney. Anything you say can and will be used against you. So just remember that everything is being recorded and don't talk about the facts of your case. If you can't afford an attorney, there is going to be a public defender in the courtroom, and there's also one that's sitting here in the courtroom with me. If you have a private attorney, when you step up to the podium, if you could please tell me their name, and if you have their telephone number. If not, we can have the state or the defense attorneys call up and see if they're available. So with that, we're going to call the first case, David Hadler. Is that a medical reset from this morning?
And it's a medical reset again, I'm being told this afternoon.
Yes, it's a medical reset, Judge.
Okay, Madam Clerk, you might want to do another form for tomorrow. Okay, thank you.
Oh, sorry.
Like that.
Most people can't see it. from now.
Okay,
It's
so we're going to start
My
with
mistake.
Jose Lobo. I'm sorry, which case are you here on?
He's a medical reset. Thank you, Judge.
Okay, thank you. Okay, Jose Lobo.
He's here, President Main Judge. He's approaching.
Okay, if everybody could announce their appearance for the record.
Eric Linder on behalf of the state.
Hector Romero with the Public Defender's Office.
Mr.
Right.
Reedy, just if you could announce your name for the record.
Brian.
I'm sorry, Judge.
If you could just, you didn't have to, if you could announce your name. just-
Oh, I'm sorry, Judge. Brian Reedy from the Public Defender's Office.
Okay. All right, and pretrial and confinement,
Rita Jackson, O-U-I-D-A Jackson from pretrial, Your Honor.
okay. Okay, thank you very much. Okay, Mr. Lobo, the court finds probable cause. You have an out-of-state hold for a felony. There is no bond, okay? You'll get a court date, an extradition court date, sir.
And
You'll appear before Judge Bailey.
nothing. Your Honor, before we move on to the next case, maybe we could take care of the case that's going to be reset for Judge Cohen tomorrow morning, just so if he might not even be back at North, but Raymond Familero.
Is that the one that I gave you? Okay, I don't need that one. Is there a
I'm sh-
Raymond?
He's in North Broward, Judge.
Okay. You know what, may I have that paperwork? I'm sorry, I misspoke. Thank you. Okay, Mr. Famularo, you are going
Yes.
to go before Judge Cohen tomorrow because of your case for a magistrate hearing. You're charged with touch or strike battery, domestic violence, and count 2, domestic battery by strangulation or dating relationship. So tomorrow morning, they'll bring you before Judge Cohen, okay?
I already went this morning.
Yeah, but he went before Judge McHugh this morning because he was only charged with a misdemeanor. He's been ad charged with a felony, so he's going to have to see Judge Cohen on that ad charge. No, it's a domestic.
Okay, so Mr. Famularo, they're gonna charge you with a felony, so you're gonna go before Judge Jeff Cohen tomorrow, and he will explain to you exactly what the charge is and so forth, okay?
Okay.
Thank you, sir. Good luck to you. Which one is this? Oh, I'm sorry. Thank you. Okay, next one is Sarai Marrero.
He's here, President Judge of Maine.
Good afternoon, ma'am. You're charged with a KPS misdemeanor and an expired motor vehicle registration over 6 months.
Judge, Ms. Moreau is inquiring if Your Honor would consider resolving her case today for time served.
Okay, this is operating without a valid license.
Correct.
Okay. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, state your first and last name.
Sarah.
Go ahead, ma'am.
Say your name for the record.
Sarah E. Marrero.
Okay, and that's Marrero.
Yes, ma'am.
Okay, state what's gonna be your, recommendation for no valid DL?
Your Honor, I reviewed her driving record. I don't see any priors, so the state's offer would be a withhold court cost judicial notice of time served. Unless, I don't know if you have her driving record, if it shows anything.
She wishes to accept the state's offer, Judge.
Okay, ma'am, you wanna give up your right to a trial and admit to the charge today by pleading guilty or no contest?
Yes, ma'am.
Is anyone forcing you to do this?
No.
Okay, the court's gonna withhold, impose court costs of $293. The court's gonna take judicial notice of time served. How much time does your client need to pay, sir? $293.
6 months, Judge.
Okay, the court will give you 6 months to pay $293. If you don't pay it, ma'am, they'll probably suspend your license, okay? If you get your driver's license. No more driving until you get a license, you understand?
Yes, ma'am.
Okay, thank you very much.
Good luck, ma'am.
Our Spanish
court will
interpreter is here,
dismiss.
Judge.
And the court is gonna dismiss that other charge, okay? Madam Clerk, the first one on there with the tag or, okay?
Judge, our Spanish interpreter is here.
Hello, how are
I
you?
believe, Spanish, Mr. Oscar Ortiz
He's-
on page 8.
he-
Senor Ortiz?
It's about, I would say, like halfway through the docket, a little less than halfway through.
Hey, Oscar Santana Ortiz?
Oscar Santana Ortiz?
Sí.
Yes.
Okay, good afternoon, sir.
Buenas tardes, señor.
You have 3 capious misdemeanors.
Usted tiene 3 órdenes de arresto por delitos de grado menor, señor.
One is for trespass on private property,
Una es entrada ilegal en propiedad privada.
one is an open container,
La otra es tener un envase abierto.
and the next one is also a trespass on private property like the first one.
Y la otra también es entrada ilegal en propiedad privada, como el primero.
Yo podría resolver este caso.
Would I be able... Adelante.
Yo podría resolver este caso con tiempo servido hoy.
Would I be able to resolve my case? Could I get time served?
Where's Mr. Romero? Is he representing him on this? Or
No, Your Honor, it's a municipal ordinance case.
Okay,
El señor Romero no lo representa porque este es un caso de la ciudad.
okay. I'm sorry, I was waiting for you, Mr. Linder, but this is a municipal ordinance case.
Sorry.
Estamos esperando a la fiscalía, pero esto de verdad le pertenece a la ciudad.
Okay, so the court would be willing to adjudicate you guilty, sir, on each charge and give you time served and impose court costs.
Señor, el tribunal estaría de acuerdo en adjudicarlo culpable para los 3 cargos y darle tiempo cumplido. También tendría que pagar los gastos del tribunal.
Okay, and Madam Clerk, do you know what the
Okay.
court costs would
Yo
be,
saldría, ¿cuándo yo saldría de aquí?
each one? Because there's 3 separate cases.
When would I get out?
Okay, I would time serve him, but I want him to understand that on each case, I have to impose court costs by law, which is $78. I could give him 6 months to pay each case.
Bien, yo le doy tiempo cumplido, señor, pero quiero que tenga en cuenta que le tengo que cobrar los gastos del tribunal para cada uno de los cargos. Sería 78 por cargo. Le daría 6 meses para pagar.
No hay ningún problema.
That's no problem at all.
Okay, raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Levante su mano derecha, usted jura y confirma que dirá nada más que la verdad.
Toda la verdad.
Okay.
Yes, the
put your
whole
hand
truth.
down, state your first and last name.
Muy bien, baje su mano y díganos su nombre y su apellido.
Oscar Santana Ortiz.
Oscar Santana Ortiz.
And it's O-R-T-I-Z for your last name?
Y se deletrea O-R-T-I-Z, su apellido.
Sí.
Yes.
Okay, it's my understanding you want to waive your right to a trial and an attorney, sir? And exchange, plead no contest to trespass in 2 separate cases, and the other one is open container today?
Señor, tengo entendido que usted va a renunciar a celebrar juicio y a que lo represente un abogado y se va a declarar que no disputa los cargos en los casos de 2 cargos de entrada ilegal y el tercer cargo de tener un envase abierto. ¿Es correcto?
Es correcto.
That's correct.
Okay, is anyone forcing you to do this?
¿Alguien lo está obligando a hacer esto?
No.
No.
Madam Clerk? Okay, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings or affect your ability, sir, to remain in the United States?
Señor, usted entiende que si no es ciudadano de los Estados Unidos, aceptar esta declaración de culpabilidad puede llevar a que usted sea deportado o puede limitar su capacidad de quedarse en los Estados Unidos?
Entiendo.
I understand.
Okay, the court's going to adjudicate you guilty, time serve you on counts 1, 2, and 3, impose court costs of $78 on each count, and the court will give you 6 months to pay.
Muy bien, la Corte entonces lo adjudica culpable, le damos tiempo cumplido para los cargos 1, 2 y 3, le cobramos $78 por cada cargo y le vamos a dar 6 meses para pagar.
Gracias.
Thank you.
Okay, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, the court will appoint one.
Tiene 30 días para apelar esta decisión. Si no puede pagar un abogado, le podemos designar un abogado para que lo ayude.
Okay.
Okay.
Thank you, sir. Good luck to you.
Gracias, señor, y mucha suerte.
No one else at Maine requires a Spanish interpreter, Judge.
Okay, you want to make an announcement, Madam Interpreter?
¿Alguien más necesita los servicios del intérprete? Por favor, notificar a la persona a cargo.
Okay, let's go to Paul Ryan, Conti, and North Broward. Is anybody there, ma'am? Can you get the deputy? Deputy, does anybody need it?
We don't need interpreter, ma'am.
Thank you.
Right.
Okay, is your name, thank you.
You're
Madam
welcome.
Interpreter.
Very nice to see you here, Your Honor.
You too.
Look forward
Thank
to
you.
working with you.
You too, thank you. Okay, Amanda Marquise.
Yes.
Okay, ma'am, you are charged with offer, agree to secure for a lewd act, first offense.
Should like to resolve it if possible, Judge.
Okay, State, are there any special conditions if we have her enter into a plea today?
Your Honor, my understanding, the only condition, and I believe it's statutory, is that Ms. Marquise would have to get a HIV test and submit the receipt of the test being taken, not the results,
Correct.
to the state attorney's office.
Okay, and how much time would she have to do that?
Your Honor, as much time as the court is inclined to give her, I have no objection to that.
Okay, all right, so would the court be willing to do an adjudication an adjudication and time served?
Would you like an adjudication in time served, Amanda?
Yes,
Okay.
please.
And
Plus
is,
court costs. Madam Clerk, what is the court cost on this? Is it $293? Okay, ma'am,
this is
is
not
that what
the
you want to
final.
do?
Yes, please, Your
Okay,
Honor.
raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, I do.
Okay, put your hand down. State your first and last name.
Amanda Marquis.
Marquis, ma'am.
Yes.
My understanding, you wish to waive your right to a trial?
Yes.
Okay, is anyone forcing you to do this?
No.
Ever been treated for a mental illness?
No.
Okay, you wish to give up your right to a trial, you said, so how do you wish to plead to offer, agree to secure for a lewd act, first offense, ma'am?
Guilty of no contest.
Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered, the court has reviewed the court file, finds probable cause for the plea, the court is gonna adjudicate you, sentence you to time served, and impose court costs of $293. Ma'am, you're gonna have to take a test, you heard the state attorney mention that?
Yeah.
Okay, the court is gonna give you 30 days to go and show the receipt at the state
Okay.
attorney's office, or would that be the clerk? Did she go
This-
to the state attorney's office?
My understanding is should be submitted to the state attorney's office.
Okay, you go to the state attorney's office here at the courthouse, okay, ma'am? You have 30 days to appeal the sentence of the court, ma'am. Good luck to you. Oh, ma'am,
Thank
how much
you.
time do you need to pay the $293?
Can you give me 6 months also?
No problem. 6 months, thank you.
Thank you.
Good luck to you. Okay, next person, Jennifer Parker. Hello, Ms. Parker. Okay, Ms. Parker, you're charged with offer agree to secure for a lewd act, first offense. Any objection to probable cause?
No, Your Honor, Ms. Parker would like to resolve this case as well, if possible.
Okay, so, state,
One moment, Judge. I have no objection to that, Your Honor.
okay, ma'am, the court would do an adjudication plus court costs of $293. And the court
Could you give
would,
me the last one back,
give you
please?
time served. The court would also give you time to pay the $293. Is that something you'd like to do today, ma'am?
Yes, Your Honor.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
Okay, put your hand down, state your first and last name, and then you can spell your last name.
Jennifer Parker, Parker.
Okay, it's my understanding you wish to waive your right to a trial.
That's correct.
Is anyone forcing you to do this?
No, ma'am.
Ever been treated for a mental illness?
No, I have not.
Okay, you understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings and affect your ability to remain in the United States, ma'am?
All right. Yes.
Okay.
Yes, Your Honor.
Understanding what I just explained to you, are you pleading guilty or no contest to count one, offer agree to secure for a lewd act, first offense?
That's correct, Your Honor.
Okay, the court is going to adjudicate you guilty and sentence you to time served, require you to pay $293 in court costs. You have to take an HIV test and bring the receipt, not the results of the test, to the state attorney's office in the courthouse here. You have 30 days to do that, okay, ma'am?
Yes, ma'am.
Okay, you have 30 days to appeal the sentence of the court. Thank you very much, ma'am.
Thank you, Your Honor.
Have a good day. DG Kenise Phillips.
And, Your Honor, before the court makes any determination, I believe the officer,
Let me just ask, are you DJ Phillip?
Yes.
Okay, thank you. Thank you.
I believe the officer incorrectly charged her with 4 counts of possession of alprazolam, 1 count for each pill, so I'd have no objection to finding a no probable cause on counts 3, 4, and 5. Well, I figured I'd say it faster.
Okay, so ma'am, you're charged with count 1, possession of cocaine. Count 2, possession of alprazolam, which is Xanax. Counts 3, 4, and 5, the court, by agreement between the state attorney and the defense, is not finding probable cause. As to counts 1 and 2, the court is going to find probable cause. State?
Your Honor, it does not appear that Ms. Phillips has ties to the community. I'm showing her permanent address on both the booking sheet and a PC affidavit is being in Lancaster, Texas.
Okay, ma'am, where is your address here? Do you have an address in Florida?
No.
Okay.
I was staying in a hotel and,
Okay, don't talk about the facts of the case.
okay.
Judge, Ms. Phillips provided me with the name of her grandmother, who she thinks might be able to post her bond. I'd ask the court to leave the bonds where they are.
Okay,
State has
I'd like to know a mailing address. Because I have the 1544 Kentucky Avenue.
Is that where you live? Is that your address?
Yeah,
You get mail there?
my address.
Okay.
1544 Kentucky Avenue, Lancaster, Texas, 75134.
Can you ask for Mr. Reedy how long she's lived there?
How long have you lived there?
2 years.
Okay, Mr. Reedy, my concern is her coming back here if she's going back there.
I don't think she should be punished because she doesn't live here, Judge. I mean, the standard bond is $1,000. There's nothing before the court other than where she happens to have an address that would aggravate that circumstance. We have a mailing address, know where to find her. She doesn't show up, a warrant goes out.
And Your Honor, just for the record, Rita from pretrial. We spoke to her friend, Peter Jason, who said that he will post a bond. He's already contacted a couple of bail bondsmen, and he's on his way to a bail bondman company. That was about an hour ago.
Did you hear that, Ms. Phillips?
Yes, I hear what she just said.
Okay. You know, you need to come back to court.
State, what's your recommendation as to bond?
Your Honor, if these were more serious charges, I would have the same exact concern as Your Honor stated on the record. But seeing as there are 2 third-degree possession charges, I have no issues with the $1,000 standard bonds.
Okay, then counts 1 and 2 will be the standard bonds. The rest, just gonna put ROR. Okay? Thank you, ma'am. Good luck to you.
Okay, thanks.
Okay. All right, next one, Catherine Kiona Branham. Hello, ma'am. How are you? You're charged with count 1, possession of cannabis less than 20 grams, possession of Xanax, alprazolam, and count possession of ecstasy, which is MDMA. Any objection to probable cause?
No, ma'am.
No, Your Honor. Let me do the talking, Ms. Brown. No objection, Judge.
Okay. State?
Your Honor, I'm she has no record. That being said, I'm showing a permanent address in Tampa. Because of lack of ties to
The
the
community.
Tri-County area, I'm just asking, again, I'll ask that these standard bonds be kept in place.
Okay, ma'am, is your address where you're still receiving mail 1309 West Yukon Street, Tampa, Florida?
Do I talk now?
Yes. Okay, Mr. Reedy, can you inquire how long she's been there?
Yeah, Judge, how long have you lived at that address? I know you lived in Florida all your life, but how long have you lived at that particular address?
18 years.
And who do you live with?
Nobody.
Okay, so, Mr.
Oh,
Reedy,
yeah, she did tell me she lives there 18. She's been living there for 18 years. I did ask her that, actually, Judge.
all right, so what are you asking for on the bond?
Judge, I'm going to ask the court to consider pretrial release. I mean, Tampa's not that far away. It's still within the state. She's given me her mother's name and number to call if she's not able to get pretrial release. She's had the same job for the last 4 years. She did 2 years of college studying social services. She doesn't have any kind of a record. And based on the nature of the charges here, I think she's a good candidate to come back. Or she's going to kind of run the rest of her life from a couple of drug charges. I don't think so. So I'd ask you to consider pretrial release for her.
I just don't know that having someone supervised from over 250 miles away, I mean, it's one thing when someone's here, they can check in if necessary, but, I mean, if the court,
But if she bonded out and there was no pretrial, then she wouldn't be calling in, she'd just be at
and
large.
it'd be,
for-
well, it would be one of 2 situations.
It
She
would
would,
be for $210.
it'd be one of 2 situations. Either she would go through a bondsman, and if she doesn't appear, and the bondsman has a chance of having the bond escheated and losing the bondsman's money, the bondsman will make it a point to go get her and bring her back. Or if she posts her bond, or a friend of her posts her bond, or family member, I would imagine that they would have a financial interest in making sure she shows up because they wouldn't want to lose the money.
Mr. Reedy?
You know, we're talking about Xanax and ecstasy, so I mean,
Can she afford to post the bond?
can you afford any kind of bond, Miss Branham? What about your mom? You think she can come up with any money to bond you out?
Possibly.
But you're not sure.
I'm not sure. Haven't been able to speak with her.
She hasn't been able to make a call to her mom because it's across the state, so I'm going to call her mom, but I can't tell the court at this point in time how much money her mother would be willing to come up with to bond her out.
Okay, so why don't we do this? Why don't we just put it on a brief recall and maybe you can call, okay?
Or in the alternative, I mean, Your Honor, my understanding, if she doesn't post out, that's also why we have second looks.
Yeah, but meanwhile, she sits in
I'm gonna
jail.
put this on a brief recall.
I'll call her mom right now.
Okay. Okay, court's gonna take a brief recess. Wait here. Ma'am? You can wait. wait here, we'll be a moment. This is what I'm gonna do. I am going to ROR her on each charge. I'm gonna put her on standard pretrial release. I am gonna have her call in 2 times a week.
Staples.
She must know, Your Honor, she has to report at least one time in person.
What's it?
So the first one time
Branham.
Correct.
when she's released.
Correct.
Okay, and suppose she gets out tonight.
Judge, generally what we've been doing is within 24 hours of their release from the jail, they have to report.
No, tomorrow morning before noon. She released 10 o'clock tonight. She will come tomorrow morning, the next business day before noon.
Of course, that's up to you, Judge.
Okay. All right, this is what I'm gonna do. If you bond out, I'm gonna have you report. Let's just make it easy within 24 hours.
They should be able to give you a map of where you need to go there at the jail, Catherine. If they don't, it's right across the street from the courthouse here in downtown Fort Lauderdale.
Okay, and pretrial, if she's released tomorrow morning, I mean, obviously at 10 o'clock.
She walks across the street, because that's where we are, Your Honor.
Correct.
Well, she's in North Broward.
Okay, okay.
So how is she gonna get there?
Sometimes they can make arrangements, give them bus passes and so forth.
Okay,
I mean, she,
But that'll be incumbent upon Miss Branham to make sure she gets there and checks in.
okay,
You understand that, Catherine? All right, good luck.
okay, thank you very much. Okay, good luck to you, ma'am. Next one is Ashley Nicole Little. Oh, I'm
I
sorry,
think we have
it's
Brittany Turner, Judge.
Brittany
She's in
Turner.
North Broward.
Said Ashley, and he says Turner.
Turner. You want Turner?
yes.
Hi.
Hello.
Good afternoon, Your Honor.
Good afternoon, Miss Turner. You're being charged with count 1, offer or secure for third act. This is your third subsequent offense. Anybody have an objection to probable cause?
No, Judge, and I've spoken to her friend Philip, who actually was here this morning. He advises me that he has already gone to the bondsman and posted her bond, so she should be getting out. I just asked the court to leave the bond at $1,000.
It has already been updated in the computer. Her bond has been posted.
All right, you're getting out.
Bond has been posted.
Thank you so much, and you guys have a blessed day. God bless you.
You too. Bye-bye.
Thank you.
Okay, next one is Ashley Nicole Little.
North Broward.
Okay, ma'am, your charge, count 1, battery on an officer, firefighter, EMT. Count 2, disorderly intox, public place, cause of disturbance. And count 3, resisting an officer or obstructing without violence. Any objections to probable cause?
No, I think there's probable cause, Judge.
Okay, the court finds probable cause on all 3 counts. State.
Your Honor, Ms. Little in 2013 had a DUI that she pled out to a careless driving. One moment. That is all I see, Judge.
Okay, your recommendation is to count 1, 2, and 3, and any special restrictions or conditions.
Your Honor, I'd be requesting a $1,000 bond on count 1, order of no alcohol or intoxicants until further order of the court.
Okay,
Judge, I'd be asking the court to consider pretrial release. As the court has already heard, Ms. Little has minimal contact with the criminal justice system. She's been a resident of South Florida for all of her life. She has friends and family here. She's been living in the same location for the last 8 years. She's studying, she graduated from FAU with a degree in elementary education, although she's currently unemployed. She's been able to provide me with the name and number of her boyfriend who would be able to bond her out if a bond was necessary. But I think considering the fact that she's been a lifelong resident and has really no prior criminal history, that she's an excellent candidate for pretrial release.
Okay, can you find out what kind of bond she could afford?
That I don't know, Judge. I mean, I can call her boyfriend if you want me to.
Sure.
Okay.
He's not gonna be able to come up with much. It'll be $100 if that.
I'd be willing to take Miss Little's word on that. If you want me to call him still, I will.
Sure.
Okay.
Okay, you ready?
Kenny says he might be able to come up with $100 in some collateral.
Okay, this is what the court's gonna do on count one. The court's gonna set your bond at $1,000. Count two, the court in count three are gonna be ROR. Ma'am, you're to have no alcohol or intoxicants, okay? Thank you very
Yes,
much.
sir.
Good luck to you. Okay, next one's gonna be Robert Anderson Heel. This is the ad charge. He has a felony. This is the one where I ROR'd him.
Yes, it is, Judge.
So he's actually gonna be before Judge Davis on February 7th, 2018. Okay, Robert Heel.
Yes, ma'am.
Conti, Your Honor.
Okay, Mr. Heel. You have a hearing set on February 7th, 2018 at 1:30. It's actually my division, but Judge Davis has taken over. So you'll appear before him. You're here on a violation of probation, which this is an ad charge. You actually were ROR'd on that charge by me.
All right, thank you.
You're welcome, sir. Good luck to you.
Thank you.
Next one's gonna be Tony Bernard Miller.
Mr. Miller's here, present at main judge. He has private counsel, Mr. Scott Rubencheck.
Okay. Someone wanna reach out to Mr. Rubencheck? I think he actually, I don't know if he was one of the attorneys. There were a bunch of them asking me to reach out to them when their clients mentioned their name during, first appearance. So can either the state or the defense do me a favor and call Mr. Rubencheck and ask him if he's representing Mr. Miller, and if he is, I will give them a call.
moment, Judge.
Just to let you know, Mr. Miller, you're set on, is that 2/29/29?
What it looks like to me, Judge.
It's 250 on the operating without. No, these are,
Mr. Linder, if he wants, I can call him, if he's gonna represent him. We can put him on speaker.
Sure.
Okay, if you could give me his number, 9, I know that.
424.
1488. Thank you.
Thank you for calling the law office of Scott Rubencheck. Unfortunately, I am unable to take your phone call at this.
Isn't that always the way?
Right.
Okay, I think it's gonna go through now, Mr. Miller.
Law office?
Yes, Mr. Rubencheck?
Yes.
Hi, it's Judge Malika, nice to talk to you again.
Hi, how are you?
Good. I actually have your client here, Tony Bernard Miller, you're representing him?
Yes.
Okay, he's here before me on count 1, a capious misdemeanor, count 2, a capious misdemeanor. The first one is at $1,000, the second one is at $250. He has a hearing actually in Division MS, which is my division, but now it's gonna actually be Judge Davis's division on
Okay.
2/9/2018 at 10
Why are you
a.m.
leaving us already?
Yeah,
You're gonna just be doing first appearance, or you're gonna be in the civil division?
no, just first appearance, that's it,
Oh, okay.
okay? So
Can we set
anyway,
it for-
do you have,
Can we set it, well, if he's not gonna be able to post the bond, can we set it before Judge Davis tomorrow morning, or can we resolve it, now,
you wanna resolve the 2 cases?
if we can?
Okay, it's possession of cannabis less than 20 grams, and the other one is no valid DL, operating without a valid DL.
If we could do a withhold court cost?
State,
One moment, Judge. Yeah, I'm fine with that.
okay, all right, sir, raise your right hand, do you swear and/or affirm to tell the truth?
Yes.
Okay, state your first and last name.
Tony Miller.
Okay, it's Tony B, as in Bravo.
Tony
Miller,
B. Miller.
Miller, put your hand down, sir. Okay, sir, your attorney has advised me that you wish to plead no contest to count 1, possession of cannabis 20 grams or less, and also operating without a valid license. Is that what you wish to do?
Yes.
Okay. Is anyone forcing you to do this?
No.
And you're giving up your right to a trial in exchange for a withhold of adjudication and court costs of $308, sir.
Okay.
Okay? All right, so this is what the court's gonna do. The court's gonna withhold adjudication and impose court costs of $308. How much time, Mr. Rubencheck, does your client need to pay?
6 months, and does he have anything else holding him in, or he's only with the rest on the outstanding cases?
This is, at this point, this is all that's holding.
This is the only thing that's holding him, okay?
Okay, thank you, Judge.
All right, good luck to you. Your client has 30 days to appeal the sentence of the court. Thank you.
Okay.
Bye.
Bye-bye. Okay. right, next one, Iram Chu Hernandez.
He's here present, Judge of Maine.
Okay. All right, Mr. Romero, your client is charged with 1 count of attaching a registration or a license plate not assigned, and count 2, failure to register a motor vehicle.
Judge, in speaking with Mr. Chu, he wishes to ask the court if you would consider resolving his case today for withhold court costs.
Is this an MM case?
Yes.
Okay.
Well,
All right.
TC, but-
All right, so the court's gonna find probable cause. If he wants to resolve it, the court will do a withhold plus court costs. Madam Clerk, what are the court costs? Just on 1 count?
He wishes to accept the court's offer, Judge.
Okay. The attaching the registration, that's an M2,
Yes, I
Okay.
believe so.
and so is a failure to register the vehicle, right?
I believe so.
Okay. All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, your name is Iram Chu, Chiu Hernandez, Hernandez.
Yes.
Okay, it's my understanding, sir, you wish to waive your right to a trial?
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol or drugs?
No.
Okay, understanding what I just explained to you, are you pleading guilty or no contest to attach a registration license plate not assigned and failure to register a motor vehicle, sir? You can put your
No
hand up.
contest.
Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered. The court is, after reviewing the file, finds a factual basis for the plea, and, the court's gonna withhold adjudication and impose court costs of $293 on count 1 only. How much time does your client need to pay?
11 months. He's asking 12 months, Judge.
Okay, the court will give you 12 months to pay $293. Thank you, sir. Good luck to you. You have 30 days to
Appreciate it.
appeal
Thank
the sentence of the court. You're welcome. All right, next one is gonna be Harvey Gary Gerard.
Medical reset.
Okay, and then we're gonna have Pedro Cordero. I believe I need to set a bond in this.
Your Honor, these 2 charges were downfiled from burglary with assault or battery to battery. I'm just gonna ask that bonds be set on each count at $1,000. He's already been ordered by Judge Cohen at his original first appearance to have no victim contact with all the complainants, so there's no need for a new no victim contact order.
Okay,
And he has a no bond hold on count 1, so
okay.
you
All
need to
right.
resolve that first, Mr. Cordero.
It's all
Okay, so
part of
the
this
court's
case.
gonna find
It's
probable
all part of the
cause.
same case.
Sir, you're charged with counts 2 and 3, touch or strike battery in each count. The court is gonna go ahead and set a $1,000 bond in each count. And you're also, sir, on these counts as well, to have no victim contact, direct or indirect. Thank you, sir, and good luck to you.
Thank you, Your Honor.
Have a good day, you're welcome. Okay, next one's gonna be Jeffrey D. Person.
Medical reset.
Okay, then the one after that is gonna be Ronald Demond Hampton.
He's approaching, Judge.
May I
Mr. Hampton,
approach your
come on over here, please.
Pardon? Sure. Okay, is this to be added to this paperwork?
Yes, there's no mention in the original probable cause affidavit of the drugs being tested.
Okay, was the original provided to the clerk?
The original PC, Your Honor? That's what the clerk provided it to you. That's
Is
what you
this
have.
it? The one that you gave me?
Oh, no, I'm just asking that you attach that so the clerk will have it with the
Okay, I'll
paperwork
attach
when we're
it now,
done.
that's why I was asking.
Oh, thanks.
Okay, all right, Mr. Ronald Demond Hampton, you're charged with count one, possession with intent to sell or manufacture or deliver cocaine. Count two, possession with intent to sell, manufacture or deliver heroin. Counts 3 and 4 are violations of probation for felony. You have 2 no bond holds. And count 5 and 6 are probation violations or community control for a felony. You also have no bond holds on those. You are gonna have your violation of probations, count 3 through 6, heard on February 5th, 2018 at 9 a.m. Any objections to probable cause?
No, Your Honor.
Okay, the court's gonna find probable cause. As to counts 1 and 2, Mr. Reading?
Well, maybe Mr. Romero can provide us with some information regarding Mr. Hampton's ties to the community, Judge.
Judge, considering he has a no bond hold, I mean, he's not getting out anywhere. So
Okay,
you have to see his division judge, whatever arguments will reserve it for that day.
okay, so counts 1 and 2 will be $2,500, the remainder will be no bond. Thank you, sir, good luck to you. Next one is going to be Marcela Meza Garcia.
We would waive formal reading of the charges.
Mr. Meza Garcia, come on up, please.
Okay, any objection to probable cause?
No, not probable cause.
Okay, the court's gonna find probable cause on counts 1 through 6.
Your Honor, on counts 1 through 3, those are punishable by life offenses. The state will be seeking a no bond hold at this time. Upon a finding of proof evident or presumption great for first appearance purposes only, Your Honor, the state believes that under Isaza v. State, that the probable cause affidavit provided satisfies the burden of proof evident or presumption great, relying upon the contents, including the statements given by the multiple witnesses, the physical evidence, namely the, one moment, Your Honor, the results of the kit that was taken, and also based on the post-Miranda statements made by Mr. Meza Garcia.
Well, I don't think the state has established proof evident presumption great at all, and I don't think Mr. Meza Garcia's statements give rise to any of the allegations. He doesn't admit to anything that he's accused of. As far as the physical evidence is concerned, again, we see this time and time again in these probable cause affidavits where they say, oh, a forensic examination was conducted and, oh, it's consistent with sexual abuse or sexual molestation, but that's not what happens. They can't tell that from an examination as to what happened to someone. They can't tell whether it's a result of some type of physical contact or whether it's a result of other things. So those presumptions that the forensic individuals come to are subject to great attack when it comes time to try the case or to prepare the case for trial. The only thing we have is the unsupported allegation by the witness, and that's not enough to establish proof evident presumption great. That's the highest standard we have is proof evident presumption great. It's higher than beyond a reasonable doubt. It's something the state really has to make an effort to reach. They presented no evidence. They've called no witnesses. All they've introduced is a probable cause affidavit, which is designed to do one thing, and that's establish probable cause. It's not designed to establish proof evident presumption great. We don't have no warrant, an arrest warrant, an affidavit, a sworn statement from the victim. We don't have any of those things presented to the court. If the state is asking the court to hold Mr. Meza Garcia with the most restrictive possible pretrial condition, which is no bond, they have to do more than just introduce a probable cause affidavit that doesn't rise to that standard. The state likes to cite Yazaza where there's a confession, and there's all kinds of other evidence in Yazaza that's not present in this particular case. And this case doesn't measure up to that, Judge. I'd ask you to set a bond for Miss Meza Garcia.
Your Honor, in the Saza, there was no rape kit where there were positive results for sexual abuse. With the alleged victim, 13-year-old victim, had a heel tear to her hymen.
But again, Judge, we don't know where that tear came from. And when push comes to shove and this witness is under oath and asked to testify, where did that tear come from? The answer is going to be, I don't know.
I don't believe counsel, under the case law, can refute proof evident or presumption grade based on speculation as to what testimony will be.
It's not speculation. They can't tell. It's a scientific impossibility to tell what caused that tear.
Okay, the court, I have reviewed the probable cause affidavit filed in your case, sir, and I find probable cause. I further find on counts 1, 2, and 3, the proof of guilt to be evident and the presumption great. Therefore, on counts 1, 2, and 3 are to be held no bond. Until further order of the court, this is without prejudice for the defendant to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. As to counts 4, 5, and 6.
Your Honor, the state would be requesting bond in the amounts of $50,000 per count. Additionally, and I should have requested this originally, obviously we would be asking for an order of no victim contact with MG.
Okay, I have EI.
No, it's Your Honor, it's MG. Actually, I'm
Okay,
sorry,
it says-
it's GM.
Okay, it says EI, but it says designated contact. Do you see that?
That's, Your Honor, that's a designated contact because the victim's a minor.
Okay, so what's the initials? Then I put the wrong one, I'm sorry.
It's okay, GM.
Okay, there's to be no contact, direct or indirect, with GM. Your argument as to 4, 5, and 6?
Doesn't really matter if you hold them no bond on 1, 2, and 3.
Okay,
Just so the record's clear, we're invoking Mr. Meza Garcia's right to remain silent, instructing the state and all law enforcement agencies under their jurisdiction not to contact Mr. Meza Garcia and attempt to elicit any statements from him whatsoever without contacting the public defender's office first. And Mr. Meza Garcia, I'm telling you, do not discuss this case with anyone. Do you understand me, sir?
Yes, sir.
okay, before I set the bond, I'm gonna impose a third condition, no contact with minors under 16 years of age or younger. Okay, the court is gonna set the bonds in count 4, 5, and 6 at $75,000 each. And count 1, 2, and 3, as I said before, are no bond. Okay, thank you. Good luck to you, sir. Next one's going to be Michael Edward Peterson.
Mr. Peterson is approaching, Judge.
Okay, good afternoon. Are you Mr. Peterson?
Yes, ma'am.
Okay, Mr. Peterson, I have today charges. Count 1, commit a third-degree felony with a weapon. Count 2, carrying concealed firearm. Count 3, possession of cannabis over 20 grams. And count 4 is possession of cocaine. Count 5 is possession of methamphetamine. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause, counts 1 through 5. Defense, what's your recommendation for bonds?
Judge, at this time, our recommendation would be to have Mr. Peterson released on pretrial release. At this time, he's unemployed. He's currently looking for work. He's living in Coral Springs with his mother. He doesn't think his mother has the financial ability to post bond. He's also reached out to his sister. Right now, his sister's a teacher at I believe a preschool facility. Right now, she doesn't have the financial resources to post a monetary bond. So that's why we're requesting, Judge, for you to consider releasing Mr. Peterson on pretrial release.
And Judge, even though there may not be an argument so much for probable cause, as far as the firearm is concerned, It appears from the probable cause affidavit that the firearm was found in the front passenger door pocket next to the co-defendant. So it was not directly or accessible to Mr. Peterson himself. And while that might be enough for probable cause, it's certainly something the court can take into consideration for bond. And I don't even know what it means when the firearm was listed as lost from the Broward Sheriff's Office. I have no idea what that means. I didn't know that they were in the habit of losing guns.
Okay. State,
Your Honor, Mr. Peterson had a burglary of a dwelling and a grand theft in 2007. Based on the totality of the allegations, I don't have an objection to a bond decrease. Would be opposing outright release to pretrial.
okay, I have his permanent address in Boston, Massachusetts. Can we get an address, a local address, please?
Yes. What's your local address?
2420 Northwest 115th Ave, Coral Springs, Florida.
Okay, can you say that a little bit slower? 2420.
Northwest 115th Ave, Coral Springs, Florida. 33065.
Your Honor, if the court could inquire, well, he's gonna hear me ask, but how long he's resided there?
I believe it's his mother's home.
So he does, so,
He's been residing in, South Florida on and off his whole entire life. However, he recently just, relocated here from Boston. He's been down here now a month. He's moved down here to be closer to his daughter and be closer with his mom and other, family members such as his sister.
Okay, is that 2420 his mother's address? Maybe I misunderstood you.
It is. It is my mother's address.
Okay, is that where he's gonna be residing?
That's correct.
Okay, and state, tell me again what you want for counts 1, 2, 3, 4, and 5?
Your Honor, I'd be asking for 1,000 per count.
Okay. And the defense is asking for just straight out pretrial?
Correct, Judge.
All right, this is what the court's gonna do. Count 1 is gonna be $1,000. Count 2, 3, 4, and 5 are gonna be ROR. And the court is gonna do standard pretrial. But while he's not employed, I want him reporting each week. So that means he would call in once a week and report once a week.
And if he gets a job, Judge?
Then he'll do the standard where he calls in twice a week, and then one time during the month he has to show up. Okay?
Yes, Judge.
Thank you very much. Good luck to you, sir. Next one is Neil Rashad
North Broward.
Cunningham. Sorry about that. Mr. Cunningham?
Yes, sir.
Good morning, sir, or good afternoon, sir. Okay, you're being charged with 1 count of possession of cocaine, count 2, possession of methamphetamine, count 3, possession of cannabis over 20 grams, and count 4, attaching a registration license plate not assigned. Is this a companion case to the other gentleman that we just had? Were these two together?
One moment, Judge. Yes.
It is?
That's what we're focused on. That's the MML. Yeah, it is his co-defendant, Your Honor.
Okay. All right, what's their priors and pending? Or
Checking
let
that
me
right now.
start this way.
Are you serious?
Does anybody have any objection to probable cause?
No, Your Honor.
Okay, the court's gonna find probable cause 1 through 4. State priors pending recommendation.
Your Honor, I see he went through diversion in Leon County for a misdemeanor possession of cannabis. I'd have no objection to pretrial supervision based under these circumstances, Your Honor, and his criminal history.
Okay, defense, what about the same that we did for the prior person?
Well, if the state has no objection to pretrial release, do you want a bond, state, or is that what you say? Just
No,
straight pretrial release?
Frankly, Your Honor, I don't, I would just, I have no objection to straight release. He doesn't have a residence that's listed outside of the state. I see a place of employment. I don't, there's, the gun charges were attributed to Mr. Peterson. I don't have the same concerns.
Okay. All right, sir, is your address 1204 Northwest 19th Ave?
Yes, ma'am.
Okay. All right, the court's gonna put him on standard pretrial. Thank you.
Good luck, Neil.
Good luck to you, sir.
Mr. Mark Alberti, you're next, come on up.
What, you guys new? Yeah, standard pretrial. That's all I order.
Mr. Alberti, judge is here at Maine.
Hey, good afternoon, Mr. Alberti. You have a violation of probation. You're being held no bond on that charge. Thank you.
Good luck.
I don't know when or where you're gonna go in front of, but they'll notify you soon. Parole, I'm sorry.
They'll come to him.
Mr. Adam Rauman. come on up.
Thanks for calling the docket, Mr. Romero. It's getting late in the day. I don't mind.
He'll call him.
He has high ambitions, Judge.
Okay,
He'll call him as long as
Need
the
another
person.
Diet
Rauman
Coke.
did decline the services of public defender.
okay, all right, Mr. Rallman, are you sure you don't want the services of, the public defender's office?
Yes, ma'am.
Okay, and you don't have a private attorney, right? Okay, all right, sir, you're being
Rallman.
charged with possession of cannabis, 20 grams or less, count 1, count
Rallman.
2, possession of MDMA, which is ecstasy, count 3, possession of LSD, count 4, possession of THC, count 5, possession of heroin, and 6 and 7 are just driver view obstructed by material, and drop or a shift load, which are 2 civil traffic infractions action. Any objection to probable cause?
Oh, Your Honor, I believe
You said he prefers the
It's all right.
Okay.
Sir, if you just hold on one moment, I believe someone bonded you out.
Okay, thank you very much.
Okay, hold on, I'll let you know.
Yes, he bonded you.
Okay, sir, you bonded. Good luck to you.
Thank you.
Okay? Oh, sir, hold on. Bring him back.
Mr. Rauman.
Sir,
Yes,
let me
Your
just verify something. Do you, live at 2225 Quincy Street, St. Petersburg, Florida?
Yes, ma'am.
Okay, just wanted to make sure that was your mailing address. Thank you. Good luck to you, sir. Okay, next one is a violation of parole for Cuevas Janad Aiken.
He's here at Maine, judge.
Okay. You have a violation of parole and you're being held no bond, sir. Thank you very much. Good luck to you. Next one is going to be Andre Joseph.
Mr. Joseph is here, present at Maine, judge.
Okay, he has a grand theft auto. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause on count 1, grand theft auto as to bond.
Your Honor, I'm gonna ask that the $1,000 bond be kept in place. Mr. Joseph was arrested 10 days ago on a capias for theft out of Judge Hurley's division. And I'm sorry, he was there was an arrest on a grand theft as well at that time. Total $2,000 bond.
What's the case number?
I'd have to find I'm sorry, the case number on the grand theft is 18772 CF10A. Additionally, criminal mischief, 2014, theft and resisting a merchant, 2014, grand theft and resisting a merchant, 2014, with a violation of probation, possession of cocaine, 2014, 2-year state prison, fleeing and eluding law enforcement and theft, 2014, with a VOP, 42-month state prison, grand theft auto, 2013, with a VOP, 42-month state prison, delivery of cocaine, 2011, theft, 06, uttering a forged instrument, 05, twice in 05. And Your Honor, on second thought, if the court's taking action, sua sponte action on the pending grand theft, then I have no objection to the $1,000 bond being kept in place.
You're talking about the 18772 CF10A?
Yes.
Okay, the court
It-
is gonna revoke that
Okay.
bond.
Then frankly, nothing further, Your Honor.
Okay, and then, defense?
I'm sorry, Judge, what did you say?
Okay, I am going to revoke the bond in the 18772 CF10A.
Explain to him now what happened.
Okay. State, do you know the victim's name? Is that with the Z? They crossed it out.
On this case,
Yes, it says Yvonne Zamis.
it looks like Yvonne
You have the
Zamet.
last name, is that with the Z?
Yeah, Zamis.
Okay.
Thank you, Judge, I did inform him that he's being held no bond and that you
Okay,
kept the
can you bring him
$1,000
back
bond
for
in
one
place.
moment? I just want to tell him he has no contact. Bring him back, Mr. Romero. No contact with the Yvonne Zamis.
He's approaching.
Okay, sir, you're to have no contact, direct or indirect, with the Yvonne Zamis, okay? Thank you very much. Thank you. Next one is Joseph Paul Bolero.
Mr. Romero's
B-I-L-L-I-R-O.
approaching.
Is count one a criminal offense?
No, yeah, usually they put it in a different order, Judge. No,
don't think
that's an
it is.
infraction, that's a traffic infraction.
That's what I thought.
Usually you see the criminal offense above the infraction.
Okay, are you Mr. Joseph Paul Bolero?
Yes, ma'am.
Okay, sir, you're charged with count one, driving on the wrong side of a divided highway, which is actually a traffic infraction, and count two is driving while license is suspended, third or subsequent offense. What can your client afford in a bond?
Judge, she advised me he cannot afford a bond. At this time, he wants to be released on pretrial release. He's 46 years old, been living here since 1985. He works for a company called All Clear, South Florida. He's a plumber. He lives in Pompano Beach with his girlfriend. They just moved into a duplex there in Pompano Beach. Judge, financially, he says he doesn't have money, or his girlfriend doesn't have money to post his bond, and he doesn't want to risk losing his job because that will have a spiral effect on him losing out on his apartment. Judge, would you consider him on standard pretrial?
Your Honor, I do have to make the court aware of, based on the nature of his priors, 1995, murder in the second degree. I would note he was sentenced to 15 months state prison. 1992, armed burglary of a structure and aggravated assault. He was sentenced to 3-year state prison. I wasn't there. I don't know. No, I hear you.
Okay, this is what the court's gonna do. The court's gonna set his
that?
bond at $100 and standard pretrial release.
$100 on count two, Your Honor?
Yes.
Okay.
All right, let me just verify his address. Do you live, sir, at 22869 Barrister Drive?
No, I was living there. That's where my auntie lives.
Okay, so what is your mailing address, sir?
That is my mailing address.
That is your mailing address, okay? All right, thank you very much, sir. Have a good day.
Any conditions, Your Honor?
Verification of his address.
Your Honor, we just asked for condition, no driving without a valid DL.
And no driving without a valid DL, sir. Okay?
Yes, ma'am.
Thank you. Okay, Demetrius Harris.
Thank you, Your Honor. How you doing, Judge?
Good.
And, Your Honor, may I approach?
Sure.
Thank you, sorry.
Okay, sir, you're charged. Should I wait till you approach, tell him what he's charged with?
Yes,
Okay,
here you go, Judge.
thank you.
Your Honor, this is, on a, change of charge.
Who has this stamp?
I'm sorry. Oh, that's, I guess the clerk stamped that upon the court ordering no victim contact. That's on the original first appearance, not, okay, Your Honor, Mr. Harris is here on change of charges. Originally counts, and I provided the court and defense counsel with a copy of Judge McCarthy's original findings at his first appearance, a copy of the information that was filed in the original probable cause affidavit. I also believe detectives testified at his first appearance on this matter. Your Honor, originally he was arrested for burglary of a dwelling across county lines. On the burglaries, they've been filed as burglary dwellings. The grand thefts, they were originally third-degree grand theft between $300 and $5,000. He's now been charged with third-degree grand theft from a dwelling property between
100 and 300.
Yes, and Your Honor, the bonds, I can tell you the bonds were set on the burglaries to $20,000 each, $5,000 each on the grand thefts, pretrial release GPS, no victim contact. I'm gonna ask that the bonds be kept in place. First, I would note, one of the reasons that, well, first off, Judge McCarthy, she took into consideration the detective's testimony, but I would also note, an aggravating factor is that Mr. Harris was literally arrested in Palm Beach County 1 week prior to this arrest for this incident. One moment, Your Honor. He was arrested December 12th of 2017 for grand theft auto and also on 2 failures to appear on misdemeanor cases. Additionally, he was arrested in July 2017 in Palm Beach for a failure to appear. November 20th, 2016, he was arrested for a failure to appear. October 11th, 2016, he was arrested for a failure to appear. He was arrested in Palm Beach County in 2011 for failing to appear, 2008 for failing to appear. I will also note, Your Honor, that Mr. Harris is scheduled for his arraignment tomorrow morning before I believe it's tomorrow morning before Judge Calra. So that is another reason why I would ask for the court to place the bond amounts where they were Judge McCarthy set them, leaving them and Mr. Harris in the same shoes that he was in at his original first appearance.
Okay, Mr. Harris, they're changing the charges on you. They're changing count 1, 2, and 3 to burglary of an unoccupied dwelling unarmed, where before it was across county lines. Is that what it was?
Yes.
Yes, that's correct, Judge.
Okay, so now it's just a simple unarmed. Count 4, 5, and 6. Before, sir, were grand theft between 300 and 5,000. Now it's grand theft third degree between 100 and 300. So, any argument, defense?
Judge, if he's going in front of Judge Calra tomorrow for his arraignment, I think they can probably work things out there. $55,000 of bond is tantamount to no bond at all from Mr. Harris.
75.
72, 46, 75, you're right, Judge. Math was, I was told there'd be no math. But Demetrius, you work this out in front of Judge Calra, all right?
Tomorrow?
Yeah, you're gonna go in front of him for an arraignment tomorrow. You meet your public defender there and advise your public defender you want a bond hearing set up to address to reducing your bond.
Understand.
Okay? Good luck, man.
Thank you.
And Your Honor, just leaving the same conditions as well, in addition, the same bond conditions that Judge McCarthy set? That's kind of what I was going for.
Well, I was gonna say that, but that's why I'm standing up. What's, Your Honor, for the record, what was count one? Count 1 through 3?
Is burglary of an unoccupied dwelling unarmed.
What the bonds are 20, each, 20,000 each, Your
No,
Honor?
now they're set at 0. It says that I'm to set them, but I was asked not to set them, to let Judge Cholera deal with it tomorrow.
No, I think,
So-
I think Mr. Reedy, and I don't wanna speak for him, but I think he meant,
Yeah, leave them at 20 each.
Okay, I'll set them at.
Unless you want to ROR him, I'll call him up and tell him he's got a $15,000 bond, see if he can get out.
Before tomorrow, because I do want to tell him no victim contact.
that was already ordered, Your Honor, that's just still.
Okay, as long as you're saying I don't have to worry
No,
about it. Thank
no,
you.
Your Honor, that is still in effect based on Judge McCarthy's order.
Your Honor, pretrial is asking Mr. Valero to come back. I need to clarify something.
Sure. Valero,
Yes.
okay.
I
Can I
will
have
just,
Valero back, please? Thank you. Is that it?
can go back to main jail, they should still have him.
No, Valero.
B-I-B-A-L,
B-A-L.
the one before
That
this
was
one.
Harris, sorry. Take your time. I'm not in a rush. Thank you.
Your Honor, just for pretrial, just for clarification, you want him straight pretrial, or did you want us to verify the address before he's released?
Judge,
Or
we'll
to
be
bond
asking
out?
you through pretrial, you impose also a $100 bond on him.
Yeah, standard pretrial, but I did want them to verify his address.
Because he
Because
told-
that was his mailing address, and we don't have any address where he's gonna be.
And he informed pretrial, my coworker called me that he said that address on his booking sheet is incorrect. He does not have a mailing address at this time.
Okay, so,
So that's why I was asking, did you want us to?
I gave you the address where we stay in Pompano though. I stay in Pompano.
And that's what he told pretrial. He couldn't give us a valid address at the time.
okay,
You want
he's
it-
gotta give a valid address, I just don't want a mailing address.
So you want it
And
pending?
$100
So
bond,
it's
yes.
pending,
Yes,
or he can bond out.
no, it's a
See, that's-
$100 bond. All right, let me do this to make it easy, I'm gonna ROR him, but pending standard pretrial, pending his address.
Your Honor, what you can do, if you want, you can set the bond at 100 and order pending verification, pretrial pending verification.
Well,
Once
that's
they,
what I wanted to do, but it
No, no,
seems
no,
like
but you
it's a
were-
problem.
No, it's
No,
not.
no, what-
No, I just want
we-
to say it for the record.
you were saying meaning it has to be both. If you make it pending verification, what happens is, once they verify the address, it becomes an ROR. He gets released and then he's on pretrial.
Okay.
And it seems like that's what your intent with what you were just saying.
No, my intent is for him not to get out on a $100 bond. I want his address verified of where he's gonna be.
Well,
That's what I'm trying to say.
so then,
So
then what you want, then what you would have to do is, for that to happen, is set a $100 bond plus pretrial. He will be released, whether they verify or not, but then it's on him to report, because, Your Honor, there's no way to do 100 and,
This is what I'm gonna do for this one, and then we're gonna talk about it later,
Okay.
okay? Let's do a standard pretrial pending verification of an address, okay? And I'm not gonna put the ROR on there, because I was told not to put it earlier.
okay,
So he's gonna stay here until we verify the address.
Yes, absolutely.
If he doesn't verify tomorrow or next week, for the record, he's gonna stay until we verify.
Correct.
do you want him scheduled for a second look, just in case?
Public Defender's Office can set it. That's
Well,
not
you
a
should
problem.
pretrial. You should
Judge, let me just tell you what's going on. I mean, right now, like I said, he just moved into his girlfriend's house. It's a duplex in Pompano Beach. Since he just moved in, he doesn't have that the phone number memorized. Right now, he doesn't also have the phone number for his girlfriend, because when he was arrested, he didn't have the phone with him. So right now, there's no information he could go ahead and give Your Honor to tell you where he's staying at right now at this very moment, Judge. So I don't want him in a position where now he's being held no bond. Now, of course, if he reports to pretrial within 24 hours of release, at that time, he'll probably go tonight, stay there, get the address, and provide it to pretrial.
I guess,
I don't know if it's your intention to have him stay in custody until he can provide you an address, which right now physically he cannot. So bottom line, he would be held no bond.
Okay, does he have his girlfriend's number? Is it in a phone somewhere? We can do
Well, he
a
didn't
phone
have his
order.
phone with him.
They didn't let
When he was arrested, he wasn't with his phone with him, so he has no way
I guess,
of providing.
Your Honor, I guess my curiosity is, if he was ROR this minute, how would he get in touch with anybody to get anywhere? If he doesn't have any information about where he'd be going? or who he'd be, with.
Maybe he can give
Lots
you
of
the.
people, when they get out there in that situation, Judge, and they go and maybe walk to
But walk to where? He just said he has no information about where he'd
He
be
knows how
going.
to get there. He could describe to you how to
Okay,
get
hold
there.
on a second.
I don't know if that's.
I get what you're saying, Mr. Romero, and I understand what your point is, and it's well taken. However, let him call his aunt or whoever it is. I think he said it was his aunt in Boca Raton. And let him get the girlfriend's number or try to figure it out. He's either gonna stay there, or we can put his address as the Boca Raton, but he's to tell, because we can do standard pretrial in Palm Beach County, right? He's to get permission before he moves anywhere from pretrial, or notify them at least 48 hours in advance.
Judge, he doesn't have no
I don't
numbers.
have they're all in my cell phone, and they left the cell phone in the car.
I don't know, I don't think we.
I don't know any numbers because all
Can
it
we
is
inquire if
just
he has a
the
cell
name.
phone in
No, they
property?
said he doesn't have a
No,
cell
yeah.
phone.
Oh, well, he's gonna.
They just, how many numbers do you know by heart?
I know my childhood phone number, because that was before the cell phone. So if I'm arrested, guess I'm gonna be here no bond as well, because I don't know phone numbers by heart.
Okay, so State, what are you recommending?
Your Honor, okay. It's really a matter of, if you want him on pretrial, your options are really, you can set a bond and have it pending verification. And if you do that, then what'll happen is he can either post $100 bond, and
But he said he can't get in touch with anybody, so.
but here's, okay, or you can ROR him to pretrial, if you want him on pretrial. Those are really the two options at this point. There's really no other.
Okay, so this is what I'm gonna do. I'm gonna ROR him to pretrial, okay? That's what I'm doing, that's the court's ruling. Thank you, sir. Next one is Carmen Giardino. Sure.
Good afternoon, Your Honor.
Good afternoon, how are you, sir?
Your Honor, this is a very technical change of charge. When Mr. Giardino was first arrested,
Hold on just one moment.
sure.
I just wanna read this. and
Of
make sure
course.
it's correct. Okay, hold on one second. With this Joseph Paul Valero, I thought he had a report one time per month.
I didn't hear you say that, Your Honor.
Okay, that's what I thought standard pretrial
No,
was.
standard pretrial is two times report, one time in person, let me get this on record. Standard pretrials report one time in person to introduce you to your officer, and then 2 times by phone.
Correct.
If you change that, we usually write it in.
No, because it said 0 there, and I thought,
No, tell 2 times by phone and 0 in person. But if you want him in person, like the other one, I wrote it down at bottom to report 1 time a month.
but he does have to report, I'm saying, the first time in
Correct.
person.
And then
Okay, that's what
afterwards,
I
twice
wanted.
by phone.
All right, thank you.
I apologize, Your Honor, for that.
No, that's okay. It just said 0 times, so I just wanted to make sure. Okay, I'm sorry, sir. You're charged with burglary of an occupied dwelling unarmed.
Your Honor, when Mr. Giardino had his first appearance, it would appear that there was a misbook, or the officer put down the wrong charge, because he was charged with burglary of an occupied structure. As you can see on Judge Ehrlich's notes, she crossed out the structure and wrote residential,
Yep,
which is what he ultimately was charged with. It was, burglary of a dwelling. It would appear that it was, the facts supported burglary of a dwelling. It just had the wrong charge listed. Based on that, since he is now before the court on the same charge that Judge Ehrlich found probable cause for, we're gonna ask that Your Honor reimpose the same bond that you set, which is $10,000, with the same release conditions.
okay. Any objection to probable cause for burglary of an occupied dwelling unarmed?
No, Your Honor.
Okay, the court's gonna find probable cause. Defense, as to bond?
Do we have a court date for him?
One moment.
Mr. Giardino, you gonna be able to make a $10,000 bond?
No, sir.
Make a $5,000 bond?
Yes, sir.
Before they had a pretrial GPS level 1.
Exactly, and Your Honor, he is also seeing he's seeing Judge Merrigan tomorrow morning. even if he wasn't though, I mean, this is even different than the last case in which it was actually a different charge than what the court found probable cause for. He's before the court on this, at the end of the day, the same charge that probable cause was found. There really shouldn't even be an appearance to determine, there really wasn't a change of charge.
Then why is it on the docket for a what again?
Mr. Reedy, you know the answer.
Carmen, you're going in front of your judge tomorrow, okay?
Yes, sir.
All right, tell your public defender that you want them to file a motion to reduce your bond,
Yes, sir.
okay? So maybe get you in court later this week, early next week on a bond hearing.
Okay, thank
Okay,
you, sir.
well,
All right,
right
good
now,
luck.
hold on, Mr. Reedy. Right now, it says on my paperwork, there's no bond on this.
Well, he's
So you're
gotta have a
requesting-
bond on it. I show a $10,000 bond.
Well, that was on the other one.
Well, it was on this count, Your Honor. That was the, Judge Ehrlich said a $10,000 bond on a burglary of a dwelling.
I understand, but it says change of charge, so as far as I'm concerned, and I know what you're saying, I still wanna set a bond.
Oh,
So this is what I'm gonna do. I'm gonna set a $10,000 bond. It's without prejudice, obviously, for him to go, or it's Judge Merrigan, you said?
Yes.
For him to address it tomorrow or in the future. And we're gonna put GPS 1. No return or contact. Anything else, state?
Nothing from the state.
Okay, anything else, defense?
No, Your Honor, good luck,
Okay, that's
Carmen.
it. Good luck.
Thank you, sir.
Good luck, sir.
Thank you, Your Honor.
You're welcome. All right, Ms. Clark, I'm gonna put, this, if you could just attach it, okay? Okay, is there anything else? I
We
think
got
had second-
one motion to release and 2 second ones.
I think we finished with that. So I have David Hadler. Didn't we do that one before?
Yes.
Okay. All right, then. Do you need this, Madam Clerk? No. Okay. Let's go to the recycle bin then. All right, so then the next thing I have
Or the
is
second
James
one,
Harriet.
Oh, no. Oh, that's 30 days.
Motion for
Conti under the
ROR.
judge.
Are you James Harriet, sir?
Yes.
Okay.
And Your Honor, an information was filed. According to Odyssey, it was filed yesterday. Charges of aggravated assault, 2 counts of criminal mischief, possession of cannabis. Yes, I believe
It
so.
says aggravated assault. This one has a deadly weapon. It's an F3.
It was filed as aggravated assault, a deadly weapon.
Okay.
And bond was set at 10,000 on the aggravated assault. No contact was ordered by Judge Raballo.
Okay, did you hear that, sir?
Yes.
Okay. So do we know when his next court date will be?
Your Honor, the clerk's office, I imagine, will be scheduling an arraignment within the next few days.
Okay. All right, sir, you'll get a notice, okay? Thank you very much. All right, then we have Kyle Bissett.
Conti.
Yes, how you doing, Your Honor?
He didn't bond yet.
Well, let me check.
No, I bonded.
He might be
did?
held on something else, so.
And I had a violation of probation,
go.
but I was reinstated, so.
Are you just waiting to get released? Is that what you're telling us?
Your Honor,
Yes, I'm
Okay.
supposed to be released February 7th. Is there any way to
Your
take
Honor.
care of this, the open container today, though?
Your Honor, may I? Your Honor, he had a VOP, he was county sentenced, so he's gonna be in custody on that till February 7th. He did post bond on this, but as a friend of the court, it's an MO. He's asking if the case can be resolved, and that's really up to you, Judge.
Okay, so he's gonna be in court till 2/7?
In custody. Yes.
I'm sorry, you said his, violation of probation, he was revoked and sentenced, or was it reinstated?
Reinstated.
Well, let me check, because sometimes it can be reinstated, revoked upon,
And what's 2/7/18?
that's.
It was a 30-day
Sir.
reinstatement. I'm sorry.
Thank you.
Hang on, Kyle.
All right.
Your Honor, it would appear his sentence, however it was resolved, his sentence involved a jail sentence on his VOP. I'm checking to see the wording in Odyssey right now.
Did this violate, was this the reason for his VOP?
I'm gonna check everything, one moment.
It's to be heard before, James, Judge Merrigan. Harry, it's going before Merrigan? Defense? Was that the? I have it on the paper, oh, wait. Roballo. Here it is, 10,000 on count one, there it is.
Your Honor, I'm looking at Odyssey, and the problem is I see the warrant that, so warrant, of course they did. I see the affidavit that was signed for this offense. I don't see. Here's all I can tell the court, Your Honor.
What's his VOP case
No,
number? Let me look it up.
It's, Your Honor, his VOP is 1710998 CF10A. When he was arrested on the 22nd, he was arrested on the offense that's before the court right now and the violation of probation on the 94806. He was scheduled for a violation of probation hearing before Judge Cohen on the 24th. At that hearing, he admitted the violation. He was, his probation was reinstated. He was sentenced to however many days in jail. Your Honor, an affidavit was,
Who represented him on the VOP?
Fair and check.
Is he a public defender?
I'm check.
Yeah. Fair
Okay,
and check.
so then why don't we do this, since he's in through 2/7, why don't we just reset it for tomorrow afternoon? And Mr. Reedy, if you could do me the favor of speaking to Mr. Barancheck and speaking with him and seeing if this'll,
I mean, if anything, I bond it out. Like, I'll just go to court when I get out if that's not a problem. It doesn't really.
okay, do we have a address for him?
That's what I'm trying to say. A warrant was an affidavit was supplemented based on this allegation. There was no warrant when he was arrested, so I can't see any other basis for the violation than the new offense, because he resolved it, you know, at the date he was given at his first appearance for the VOP.
If that's the case, it most likely is. And this entering a plea was probation.
Your Honor, I can't imagine what the.
Check with Mr., whoever his public defender is?
The affidavit is, if you want to come take a look.
Yeah, I'd seen the tongue forward of myself, yeah.
Here, and I'll show you what I'm referring to.
Okay, sir, let me ask you this, what is your address?
1950 Harding Street.
And it's dated January 22nd.
How long have you lived there?
It's the open container. Right?
About
Okay,
2 years now.
So here.
That's Hollywood?
And if you see, here's
Yes,
where he was
Hollywood,
arrested.
Florida 33020.
And then he
Okay,
had his
Madam
first
Clerk,
VOP
can I ask you what you have for his address, if that's it?
It's safe to
That's
get
what I'm
rid
saying,
of
that's what I'm
this.
I
saying.
can
Safe to
repeat
get
it again,
rid
I
of
wrote it down.
Well, because you're defense. You're not representing her, you're just, letting her know what.
I can tell you, Judge, if you wanted, I think he's safe to take a plea because this was part of the warrant on the VIP, so when Judge Cohen sentenced him to the time in
I'd
jail.
rather ROR him and let him, I'm just,
What's the bond?
I mean, I posted bond, so
I see.
if you want, I'll just.
You can always, as a friend of the court, if you wanted to plea, you can always make a condition that if this should have an effect on his probation, that, you can vacate the plea.
Then I'll allow him to withdraw the plea.
Well, or no, you'd vacate the, vacate the plea. Once it's resolved, I don't know that it can be withdrawn,
Okay,
but the
sir.
court can vacate.
Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, I do.
Okay. State your first and last name.
Kyle Bassett.
Bessette.
Yes.
Okay, it's my understanding you wish to waive your right to an attorney in trial.
Yes, I do.
Is anyone forcing you to do this?
No.
You under the influence of any alcohol, drugs, or medication?
No, I'm not.
Okay, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, I am.
Okay, you understand that by you pleading to this charge, carrying an open, uncovered beverage in public, that this could affect your probation?
Yes, I do.
Okay, and having that in mind, sir, do you still wish to go forward and plead no contest to carry an open, uncovered beverage in public?
Yes, I do.
Okay. Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause and a factual basis for the plea. The court is gonna sentence you to a withhold of adjudication plus court costs. You know what the court costs are, Madam Clerk?
Okay.
Of $78. The court will give you 90 days to pay the $78, okay, sir? And the court will allow you, if this does affect your probation for some reason, then the court will allow you to vacate your plea in this case, okay?
All right. So it's time served.
Time served, sir.
All right.
No,
thank
I'm
you,
sorry,
Your
the court's gonna take judicial notice of time served. I gave you a withhold with no conviction plus court costs, okay?
All right.
Good luck to you. You have
All right.
30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed.
All
Thank
right.
you, sir.
So February 7th is.
February
All right.
7th, whatever's going on with your other case, okay?
All right. Thank you, Your Honor.
Thank you. Have a good day.
All right.
Okay, Antoine McIntyre.
Mr. McIntyre, is here present at me?
Okay, thank you, Deputy. Have a good day.
Your Honor, on Mr. McIntyre, he's being held on count 2 on a out-of-county VOP. I have no objection if the court's inclined to ROR him on this count.
Judge, she wishes to accept the state's recommendation as far as an ROR, so then Polk County can come and pick him up. Oh, you can dismiss it? No, they can't do that.
Okay, all right. So,
Yeah,
sir,
usually
the
don't get
court
turned down.
is going to ROR you on count 1, possession of cannabis, 20 grams or less. I would like to verify his address with the clerk's office. Does anybody have his address? Do you have it, Madam Clerk? Or, sir, if you could give me your address.
2401 15th Street.
Say that
Fort
again, I'm sorry.
Lauderdale. 2401 15th Street, Fort Lauderdale, Florida. 33311. Apartment 2.
But it's 2401 Northwest, Southwest.
I get 15th Avenue and 15th Street always mixed up. I'm sorry. It's 15th Avenue, I guess. Then. Yes, it's 15th Avenue. And Dillard is in Dillard Park, Florida.
And where?
It's in Dillard. That's the name of the neighborhood, Dillard. It's in Dillard. But it's
Okay, but-
2401.
It's not southeast or, it's not southeast, southwest 15th Avenue?
It's northwest, 15th Avenue.
Okay, is that what you have? Okay. All right, sir, good luck to you. The court's gonna ROR you. Thank you. All right, so Madam Clerk, this is what I did. I put this gentleman's address here, and the 1950 Hardin Street is for Kyle Bissett. So if you could just check it. Thank you so much.
All right, folks, we'll see you tomorrow.
Bye-bye.
Clerk, always a pleasure.
Thank you.
Maybe my voice will come back tomorrow and I
Facts, and